Hello, everyone, and welcome to my case summary on Burnham versus Superior Court. This is a Supreme Court decision, and it's a big one on tag jurisdiction, aka transient presence. So, this is a 1990 decision with a plurality by Scalia and some notable concurrences by Brennan and Stevens. So, let's get into the facts here. Dennis Burnham married Francie Burnham in 1976 in West Virginia. They moved to New Jersey, where they then had two kids, but then in 1987, they separated. They agreed that Mrs. Burnham, who had moved to California, would take custody of the kids, and shortly before she departed for California, they agreed that she would file up for a divorce on grounds of irreconcilable differences. Mr. Burnham filed for divorce in New Jersey on grounds of desertion, but he didn't obtain a summons against his wife, and he didn't serve her with process. So then Mrs. Burnham unsuccessfully demanded that Mr. Burnham, the petitioner, adhere to their irreconcilable differences agreement, and then sued in California for divorce. Mr. Burnham ended up visiting California on business. Then he went to visit his kids near San Francisco, where Mrs. Burnham lived, and when he visited it, he was served with a California court summons. Then he returned to New Jersey. And after he returned to New Jersey, he argued to quash the service of summons, saying that his only California contacts were his short business trips and his visitation with his kids. So this case makes it to the Supreme Court, and we have a question of whether or not this California court can lawfully exercise jurisdiction. As we see here, does due process prevent California from having jurisdiction over a non-resident who was personally served with process while temporarily in that state in a suit unrelated to his activities in the state? And what's the Supreme Court going to say? The plurality by Justice Scalia says that transient presence is still a basis for establishing personal jurisdiction. He says that history establishes this and that it should be the test for determining that it's legitimate. It was permissible at the time that the 14th Amendment was ratified, so of course it would be permissible now. And he, of course, distinguishes Schaefer from this case. He points out that in Schaefer v. Heitner, it involved nothing more than jurisdiction over an absent defendant, and it stands for nothing more than the proposition that when a minimum contact that is a substitute for physical presence consists of property ownership, it must, like other minimum contacts, be related to the litigation. Then Justice Brennan has a concurrence. He says, yeah, I agree that history is important, that it sheds some light on this, but I don't think it's the only factor we should look at. So he concurs to write on separate grounds, saying, I think that I agree with the judgment, but I would do it by undertaking an independent inquiry into the fairness of the prevailing in-state service rule. Reliance solely on historical pedigree is foreclosed by International Shoe and Schaefer, and that's because those cases modified Pennoyer versus Neff, which was a historical case. So yeah, he's saying that's kind of the flaw in using history as the test for why a certain kind of jurisdiction being exercised by courts is legitimate. And Stevens' concurrence, says there's no need to decide on any sort of test to use for this case. It's very easy. The plurality is correct, but I don't think we even need to bother with looking at the history. So the key takeaway is that tag jurisdiction is legitimate. And I feel like tag jurisdiction is so much better for you to say in order to think about this case, because it's simple, and who doesn't love a good game of tag? So someone comes into one state's jurisdiction, another person has a claim against them, they realize they came there, and they go play tag with them. They say, you're it, you have been served, see me in court. And of course, there are limitations to this. So you can't fraudulently induce someone to come into a state. You can't threaten someone, coerce someone to come into a state so that you can serve them with process. And there is actual case law on that, where courts have dismissed cases for lack of personal jurisdiction because the tag jurisdiction was based solely on coercion or fraudulently trying to bribe someone to enter a state. Like, I think giving them free movie tickets or something like that, or to a Broadway show. Yeah, people have tried all sorts of weird stuff for this type of thing. But yeah, tag jurisdiction is legit, and you need to know that for your civil procedure exam. But yeah, I hope that you get an A+ on your civil procedure exam. I am here for you. Let me know what you think in the comments. Let me know if there's anything that's unclear about this case in the comments. As always, if you found this video interesting, insightful, or helpful, please leave a like, comment, or subscribe to the channel. I'm really trying to push out more videos, trying to grow this channel. As always, thank you so much for watching, and I look forward to speaking to you in the next video.